This is part 43 as far as our lecture series is concerned. Now, at the time when we dealt with the trial before a court of session, or when we dealt with various courts that are constituted by the provisions of the Criminal Procedure Code and their powers, as far as the power of court of session is concerned, it has got power to pass any sentence authorized by law. But during the course of learning this power, we have learnt one aspect, and that is, whenever death sentence is pronounced or inflicted by a court of session, a death sentence is required to be confirmed, or it requires confirmation of the High Court. And hence, if there is a case where the session judge has passed a death sentence, what are the steps that are required to be taken by the court of session is dealt as far as chapter 28 of the Criminal Procedure Code is concerned, right from section 366 up to section 371 of the Criminal Procedure Code is concerned. The heading of the chapter is Submission of Death Sentences for Confirmation. And section 366 says, subclause 1 says, when the court of session passes a sentence of death, the proceedings shall be submitted to the High Court, and the sentence shall not be executed unless it is confirmed by the High Court. By the High Court shall not, and the sentence shall not be executed unless it is confirmed by the High Court. Subclause 2 says, the court passing the sentence shall commit the convicted person to jail custody under a warrant. Subclause 2 says, so section 366 says, sentence of death to be submitted by a court of session for confirmation to the High Court as far as this section is concerned. Section 367 says, power to direct further inquiry to be made or additional evidence to be taken. And subclause 1 says of section 361, if when such proceedings are submitted, the High Court thinks that a further inquiry should be made into or additional evidence taken upon any point bearing upon the guilt or innocence of the convicted person, it may make such inquiry or take such evidence itself, or direct it to be taken by court of session. Subclause 2 says, unless the High Court otherwise directs, the presence of the convicted persons may be dispensed with when such inquiry is made or such evidence is taken. Subclause 3 says, when the inquiry or evidence, if any, is not made or taken by High Court, the result of such inquiry or evidence shall be certified to such court. Section 368 says, power of High Court to confirm sentence or annul conviction. And it says, if in any case submitted under section 366, the High Court, subclause A says, may confer the sentence or pass any other sentence warranted by law. B, may annul the conviction and convict the accused of any offence of which the court of session might have convicted him, or order a new trial on the same or on amended charge. Or may, subclause C says, or may acquit the accused person, provided that no order or confirmation shall be made under this section until the period allowed for preferring an appeal has expired, or if an appeal is presented within such period until such appeal is disposed of. Now, the provisions as far as appeals are concerned with which we shall be dealing right from section 372 up to section 394 during course of our lectures. Section 369 says, confirmation or new sentence to be signed by two judges. And it says, in every case so submitted, the confirmation of the sentence or of any new sentence or order passed by the High Court shall, when such order consists of 2 or more judges, be made, passed and signed by at least 2 of them. Section 370 says procedure in case of difference of opinion, and it says where any such case is heard before a bench of judges and such judges are equally divided in opinion, the case shall be decided in the manner provided by section 392, with which we shall be dealing in detail at the time of discussing provisions regarding appeal, right from section 372 up to section 394 of the Criminal Procedure Code. With this now, section 371 lays down procedure in cases submitted to High Court for confirmation, and it says in cases submitted by the Court of Session to the High Court for the confirmation of a sentence of death, the proper officer of the High Court shall, without delay, after the order of confirmation or other order has been made by the High Court, send a copy of the order under the seal of the High Court and attested with his official signature to the Court of Session. So this is regarding submission of death sentences for confirmation, for which, as I told you, we have to deal right from section 366 up to section 371 of the Criminal Procedure Code. With this now, during the course of the trial, if the court comes to the conclusion, or if the court is of the opinion that the accused person is a person of unsound mind, as a result of which it is not possible for him to follow the procedure that is going on as far as the trial is concerned, that will definitely be not in the interest of the justice, because the right to hear and to be heard is the basic principle. It is one of the natural principles as far as administration of criminal justice is concerned. So you have a person who is physically present but mentally absent. In such a case, what is required to be done? If because of the unsoundness of mind it is not possible for him to follow or understand what is going on in a court of law, naturally the trial is required to be adjourned, the trial is required to be postponed till what time? Till the time he becomes a person of sound mind and his state of the mind is such that he is in a position to understand the proceedings which are going on in a court of law is concerned. If the accused person was a person of unsound mind at the time when the act was done by him, and because of the unsoundness of mind he was incapable of knowing the nature of the act, or that what he was doing was either wrong or contrary to the law, then naturally he is protected as far as section 84 of the Indian Penal Code is concerned. So he was a person of sound mind at the time when the act was done by him, but now if he becomes a person of unsound mind, it is irrespective of the nature of the trial, then chapter 25 of the Criminal Procedure Code comes into operation, which says provisions as to accused person of unsound mind, which starts right from section 328 up to section 339 of the Criminal Procedure Code. And 328 says procedure in case of accused being lunatic. Subclause 1 says, when a magistrate holding an inquiry has reason to believe that the person against whom the inquiry is being held is of unsound mind and consequently incapable of making his defense, the magistrate shall inquire into the fact of such unsoundness of mind and shall cause such person to be examined by the civil surgeon of the district or such other medical officer as the state government may direct, and thereon shall examine such surgeon or other officer as a witness and shall reduce the examination to writing. Subclause 1, capital A says, if the civil surgeon finds the accused to be of unsound mind, he shall refer such person to a psychiatrist or clinical psychologist for a care, treatment and prognosis of the condition, and the psychiatrist or other clinical psychologist, as the case may be, shall inform the magistrate whether the accused is suffering from unsoundness of mind or mental retardation, provided that if the accused is aggrieved by the information given by psychiatrist or clinical psychologist, as the case may be, to the magistrate, he may prefer an appeal before the medical board, which shall consist of a head of psychiatrist unit in the nearest government hospital, b faculty member in psychiatrist in the nearest medical college. Subclause 2 says, pending such examination and inquiry, the magistrate may deal with such person in accordance with the provisions of section 330. Subclause 3 says, if such magistrate is informed that the person referred to in subsection 1 capital A is a person of unsound mind, the magistrate shall further determine whether the unsoundness of mind renders the accused incapable of entering defense, and if the accused is found so incapable, the magistrate shall record a finding to that effect and shall examine the record of evidence produced by the prosecution, and after hearing the advocate of the accused, but without questioning the accused, if he finds that no prima facie case is made out against the accused, he shall, instead of postponing the inquiry, discharge the accused and deal with him in the manner provided under section 330. Provided that if the magistrate finds that the prima facie case is made out against the accused, in respect of whom a finding of unsoundness of mind is arrived at, he shall postpone the proceeding for such period as in the opinion of the psychiatrist or clinical psychologist is required for the treatment of accused, and order the accused to be dealt with as provided under section 330. Subclause 4 says, if such magistrate is informed that the person referred to in subsection 1 capital A is a person with mental retardation, the magistrate shall further determine whether the mental retardation renders the accused incapable of entering defense, and if the accused is found so incapable, the magistrate shall order closure of inquiry and deal with the accused in the manner provided under section 330. 329 lays down procedure in case of person of unsound mind tried before a court, and it says, if at the trial of any person before a magistrate or court of session, it appears to the magistrate or court that the person is of unsound mind and consequently incapable of making his defense, the magistrate or the court shall, in the first instance, try the fact of such unsoundness and incapacity, and if the magistrate or the court, after considering such medical and other evidence as may be produced before him, or it is satisfied of the fact, he or it shall record a finding to that effect and shall postpone further proceeding in the case. Subclause 1 capital A says, if during trial the magistrate or court of session finds the accused to be of unsound mind, he or it shall refer such person to a psychiatrist or clinical psychologist for care and treatment, and the psychiatrist or clinical psychologist, as the case may be, shall report to the magistrate or the court whether the accused is suffering from unsoundness of mind, provided that if the accused is aggrieved by the information given by the psychiatrist or clinical psychologist, as the case may be, to the magistrate, he may prefer an appeal before the medical board, which shall consist of a head of psychiatrist unit in the nearest governmental hospital, b a faculty member in psychiatrist in nearest medical college. Subclause 2 says, if such magistrate or court is informed that the person referred to in subsection 1 capital A is a person of unsound mind, the magistrate or the court shall further determine whether unsoundness of mind renders the accused incapable of entering defense, and if the accused is found so incapable, the magistrate or court shall record a finding to that effect and shall examine the record of evidence produced by the prosecution, and after hearing the advocate of the accused, but without questioning the accused, if the magistrate or court finds that no prima facie case is made out against the accused, he or it shall, instead of postponing the trial, discharge the accused and deal with him in the manner provided under section 330. Provided that if the magistrate or the court finds that a prima facie case is made out against the accused, in respect of whom a finding of unsoundness of mind is arrived at, he shall postpone the trial for such period as, in the opinion of the psychiatrist or clinical psychologist, is required for the treatment of the accused. If the magistrate or court finds that a prima facie case is made out against the accused and he is incapable of entering defense by reason of mental retardation, he or it shall not hold the trial and order the accused to be dealt with in accordance with section 330. Now, section 330 deals with release of person of unsound mind pending investigation or trial, and it says, subclause 1 says, whenever a person is found under section 328 or section 329 to be incapable of entering defense by reason of unsoundness of mind or mental retardation, the magistrate or court, as the case may be, shall, whether the case is one in which bail may be taken or not, order release of such person on bail, provided that the accused is suffering from unsoundness of mind or mental retardation which does not mandate inpatient treatment, and a friend or relative undertakes to obtain regular outpatient psychiatric treatment from the nearest medical facility and to prevent from doing inquiry himself or to any other person. Subclause 2 says, if the case is one in which, in the opinion of the magistrate or court, as the case may be, bail cannot be granted, or if an appropriate undertaking is not given, he or it shall order the accused to be kept in such a place where a regular psychiatric treatment can be provided, and shall report the action taken to the state government, provided that no order for the detention of the accused in a lunatic asylum shall be made otherwise than in accordance with such rules as the state government may have made under the Mental Health Act of 1987. Subclause 3 says, whenever a person is found under section 328 or section 329 to be incapable of entering defense by reason of unsoundness of mind or mental retardation, the magistrate or the court, as the case may be, shall, keeping in view the nature of the act committed and the extent of unsoundness of mind or mental retardation, further determine if the release of the accused can be ordered, provided that if, on the basis of medical opinion or opinion of specialist, the magistrate or court, as the case may be, decide to order discharge of the accused as provided under section 328 or section 329, such release may be ordered if sufficient security is given that the accused shall be prevented from doing inquiry to himself or to any other person. If the magistrate or the court, as the case may be, is of opinion that discharge of the accused cannot be ordered, the transfer of the accused to a residential facility for persons of unsound mind or mental retardation may be ordered, wherein the accused may be provided care and appropriate education and training. Section 331 says resumption of inquiry or trial, and its subclause 1 says whenever an inquiry or trial is postponed under section 328 or section 329, the magistrate or court, as the case may be, shall at any time after the person concerned has ceased to be of unsound mind, resume the inquiry or trial and require the accused to appear or to be brought before the magistrate or the court. Subclause 2 says when the accused has been released under section 330 and the sureties for his appearance produce him to the officer whom the magistrate or the court appoints in this behalf, the certificate of such officer that the accused is incapable of making his defense shall be receivable in evidence. Section 332 says procedure on accused appearing before magistrate or court, and it says if when the accused appears or is brought before the magistrate or court, as the case may be, the magistrate or court considers him capable of making his defense, the inquiry or trial shall proceed. Subclause 2 says if the magistrate or the court considers the accused to be still incapable of making his defense, the magistrate or court shall act according to the provisions of section 328 or section 329, as the case may be, and if the accused is found to be of unsound mind and consequently incapable of making his defense, shall deal with such accused in accordance with the provisions of section 330. Section 339 says when accused person to have been of sound mind, and it says when the accused person appears to be of sound mind at the time of inquiry or the trial, the magistrate is satisfied from the evidence given before him that there is reason to believe that the accused committed an act which, if he had been of sound mind, would have been an offense, and that he has, at the time when the act was committed by reason of unsoundness of mind, incapable of knowing the nature of the act or it was wrong or contrary to the law, the magistrate shall proceed with the case, and if the accused ought to be tried by the court of session, commit him for trial before the court of session. Section 334, judgment of acquittal on the ground of unsoundness of mind, and it says whenever any person is acquitted upon a ground that at the time at which he is alleged to have committed the offense, he was, by reason of unsoundness of mind, incapable of knowing the nature of the act alleged as constituting the offense, or that it was wrong or contrary to the law, the finding shall state specifically whether he committed the act or not. Section 335, persons acquitted on such ground to be detained in safe custody, and subclause 1 says whenever the finding states that the accused person committed the act alleged, the magistrate or court before whom to which the trial has been held shall, if such act would, but for the incapacity found, have constituted an offense, order such person to be detained in safe custody in such place and manner as the magistrate or the court think fit, or order such person to be delivered to any relative or friend of such person. Subclause 2 says no order for the detention of the accused in a lunatic asylum shall be made under clause small a of subsection 1 otherwise than in accordance with such rules as the state government may have made under the Indian Lunacy Act of 1912. Clause 3 says no order for the delivery of the accused to a relative or friend shall be made under subclause small b of subsection 1 except upon the application of the relative or friend and on his giving security to the satisfaction of the magistrate or the court that the person delivered shall be properly taken care of and prevented from doing injury to himself or any other person. B. produced for the inspection of such officer at such times and places as the government may direct. Subclause 4 says, the magistrate or court shall report to the state government the action taken under subsection 1. Section 336 says, power of state government to empower officer in charge to discharge. And it says, the state government may empower the officer in charge of jail in which a person is confined under the provisions of section 330 or section 335 to discharge all or any one of the functions of the Inspector General of Prison under section 337 or section 338. Section 337 says, procedure where lunatic prisoner is reported capable of making his defense. And it says, if such person is detained under the provisions of subsection 2 of section 330, and in a case of a person detained in jail, the Inspector General of Prison, or in a case of a person detained in lunatic asylum, the visitor of such asylum, or any two of them shall certify that, in his or their opinion, such person is capable of making his defense, he shall be taken before magistrate or court as the case may be, at such time as the magistrate or court appoints, and the magistrate or court shall deal with such person under the provisions of section 332, and the certificate of such Inspector General or visitors as aforesaid shall be receivable as evidence. Section 338 says, procedure when lunatic detained in declared fit to be released. And subclause 1 says, if such person is detained under the provisions of subsection 2 of section 330 or section 335, and such Inspector General or visitor shall certify that, in his or their judgment, he may be released without danger of his doing injury to himself or to any other person, the state government may thereupon order him to be released, or to be detained in custody, or to be transferred to public lunatic asylum if he has not been already sent to such an asylum, and in a case it orders him to be transferred to an asylum, may appoint a commission consisting of judicial and 2 medical officers. Such commission shall make a formal inquiry into the state of mind of such person, take such evidence as is necessary, and shall report to the state government, which may order his release to detention as it thinks fit. With this now, section 339 says, delivery of lunatic to a care of relative or friend. Subclause 1 says, whenever any relative or friend of any person detained under the provisions of section 330 or section 335 desires that he shall be delivered to his care and custody, the state government may, upon the application of such relative or friend, and on his giving security to the satisfaction of the state government that the person delivered shall be properly taken care of and prevented from doing injury to himself or to any other person, be produced for the inspection of such officer at such time and places as the state government may direct. In a case of a person detained under subsection 2 of section 330, be produced when required before such magistrate or court order such person to be delivered to such relative or friend. Subclause 2 says, if the person so delivered is accused of any offence, the trial of which shall have been postponed by reason of his being of unsound mind, as incapable of making his defense, and the inspecting officer referred to in subclause small b of subsection 1 certifies at the time to the magistrate or the court that such person is capable of making his defense, such magistrate or court shall call upon the relative or friend to whom such accused was delivered to produce him before the magistrate or court, and upon such production the magistrate or court shall proceed in accordance with the provision of section 332 and a certificate of inspecting officer shall be receivable as evidence. With this now, if the order is passed, if the judgment is passed by the court, the order may be that of conviction or acquittal, and either of the parties is likely to be aggrieved by the decision which is given by the lower court. Now, in order to have some remedy, there is a provision of appeal which is laid down right from section 372 up to section 394 of the Criminal Procedure Code. So now, during the next part of our lecture, we shall be dealing right from section 372 up to section 394 of the Criminal Procedure Code. We shall deal with appeals in detail.